was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a
We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. And certainly there are rules regarding prosecutorial misconduct. I think council is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say, don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the
I think
court
it's
on
the
the
defendant's
filings.
motion, so if they want to argue it, they can.
It's the state's motion.
Oh, is it the state's
It is the
motion?
state's
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger or something of that nature, as I
Yes,
understand.
Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions. And that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act.
It's the rule says other acts to show knowledge or plan, and so the state has expressed that they plan
That's
to use
how you
that
can use it.
paper.
It's
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of sort of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with the Amazon
I
records.
don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is in essence trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
It's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
That is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, well, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in run on that rule.